Madam Mayor, I'm not sure if I'll meet my time limit, so I've distributed my comments in writing. Madam Mayor, members of the City Council, I'm Jeff Lewis, and I represent the residents in this litigation against the city. I'm here to advocate in favor of the city approving the settlement. This settlement was reached as a result of a 14-hour mediation attended by all parties to the lawsuit. I'll point out that the mayor, at hour 10, asked me to stay. I wanted to walk out, so thank you for making me stay.
You're welcome.
Like every good settlement, there's something in the agreement that everybody does not like. Personally, I don't like that the Lugliani family gets to keep 1 inch of parkland. If I went to trial, odds are that parkland would be ordered out of the Lugliani family. But trials are never 100% certain, and you never know until the judge signs on the dotted line. And the concessions made by the Homes Association, the city, at the mediation outweigh my personal distaste for this outcome. I'm trying to look beyond this one parcel for the whole city's benefit. I also don't like that my law firm is walking away from $250,000 in attorney's fees that I could earn in the road litigation. But I'll write that time off because for the greater good of the city, I think this settlement is a good outcome. The benefits of the settlement include that the most publicly visible and usable portions of the parkland on Via Panorama will remain public parkland, and all of the encroachments visible from Via Panorama will be removed. 2 lawsuits will end, and let me outline the consequences of not settling today. And I don't do this as a threat, but just to be clear on the consequences of not settling. A trial will be held. If I win, I will make a motion for my attorney's fees. That motion will be at least $500,000, and the city would be jointly and severally liable for that amount. As part of this settlement, the city's not paying a nickel. It's a good outcome for the city. If trial goes forward on February 14, it's probable that the loser will appeal. And that means another 2 years of litigation. Nobody needs that. If this case is not settled, it is probable that the other lawsuit will continue for years. Nobody wants that. And in conclusion, let me say that continuing to litigate sends the message to residents that the city thinks parkland is for sale. Continuing to litigate sends the message that if there's a financial crisis, the city wants flexibility to sell parkland. Settling today sends the message that the 2012 transaction with the Luglianis was at the least a unique circumstance that will never be repeated in PVE. I would encourage each council member when they make their vote on this settlement to clearly state for the public that parkland is not for sale in PVE. And unless there are any questions, that concludes my comments.
I have a question, Jeff.
Yes, sir.
In your conclusion, you state that continuing to litigate sends the message to residents that the city thinks parkland is for sale. Why is that?
Well, my position is that the transaction involving the city that Christie outlined in her preliminary comments was invalid. The city takes the position that that transaction is valid. I'm asking this judge to hold that it was invalid, that the city may not participate in a global MOU transaction where it knows a public park is going to go from the public hands to a private hands, that the city can't just look at one transaction, you got to look at the entire MOU. So I'm not accusing any of the 5 of you of taking the position of wanting to sell parkland, but I am saying continuing to litigate appears to the public as though you are fighting for the right to have maximum flexibility to sell parkland in a financial crisis. That's the way it's viewed.
See, Jeff, there are some people that believe that by settling this, it means exactly the opposite. Because by agreeing to this settlement, we are selling parkland, period.
I don't know that I
Can you dispute that?
I can dispute that.
Let's hear.
Because, first of all, the 2012 transaction was a result of a perfect storm of circumstances. And what this is doing is affirming one piece of that perfect storm where the Luglianis get to keep the portion of the property that's on a hillside that's not visible to the public and they can't see it, okay? As to that property, right now, as of this moment of time, the Homes Association owns that property. If this transaction concludes, it's going to go to the Luglianis. The city is not part of that transaction today in 2019.
But does the land still go to the Lugliani?
It will absolutely, that portion of the land that the public can't see and doesn't hike through will absolutely go to the Luglianis.
Has that ever happened before?
You know, we had some conversations about that. I can't say for certain whether or not that has ever happened before, but I can.
I can. It's
Okay.
never happened before.
But let me just say this. In my view, and perhaps Christie will chime in, the transaction contemplated by this settlement was a really unique set of circumstances that would be very difficult to replicate in the future, both in terms of the litigation that I commenced and the 2012 transaction. I can't imagine that ever happening again. It would require, for that to happen again, a council and a homes association board to interpret the CC&Rs in a way that permitted a public piece of property to go to a private owner. And I just can't see that happening.
Thank you.
You're welcome. Any other questions?
Any other questions? No? Thank you, Mr. Lewis.